Yes.
Okay, you ready, Mr. Barker?
Yes.
Okay, then we'll go on the record and file 15 CF 627, a case entitled State of Wisconsin versus James Barker III. You'd state your appearances for the record, please.
Wiedenfeld appears for the state.
And Mr. Barker, you're appearing in person without counsel, is that right?
Yes, pro se.
Okay. Before we begin looking at the merits of the things we're talking about today, I'll ask all people in the courtroom to please turn off your telephones, please. Make sure they're off all the way. There is no allowed recording of this event, either audio or visual. So if you're recording, they will take your phone from you or make you turn it off. You may not record. The only recording allowed here pursuant to the Supreme Court rules, a request for a videographer to be present, and one is present. And sir, what is your name, please?
Jim Spodek,
You spell your last name?
S-P-O-D-I-C-K.
And you're representing,
Talking Racine in
Okay.
a documentary pattern.
all right. That request was made through the proper channels pursuant to state Supreme Court rule to allow cameras in the courtroom. And that procedure's been followed, and he's allowed to be here, but no one else may record this proceeding in any way, audio or visual. Anyone have any questions about that? All right, then we'll go forward. We have two matters today that have been filed. One is a brief, or a motion rather, filed by Mr. Barker on his own behalf, asking this court to recuse itself. Mr. Barker, do you want to be heard on that motion?
Yes.
Go ahead and make a statement if you wish.
Okay, I filed with the courts on February 4th, on April 4th,
April 4th, right?
Okay. A defendant's notice of motion and brief to object to the assignment of youth drug people take under says, now comes the defendant James A. Barker, appearing pro se, preserving the rights to challenge the court's jurisdiction, move the court for an order for recusal of Racine County Circuit Court Judge Gerald P. Patek. The action is pursuant to U.S. Code 455 AB 134, Wisconsin Supreme Court, Chapter 6 and 75719 2G 801.56 97122, Racine County Court Rules, Section 6A, E1, Wisconsin Statute 89.07, 89.08, Section 15, 19.35, Section 1, 137.01, Section 4A, Wisconsin Court of Appeals, Published Opinion, 20118P2282, State versus Wilton Tye, 201 Wisconsin 124, U.S. Constitution, Amendments 4, 5, 6, 8, 13, and Wisconsin Constitution, Article Section 1, Articles 1, Section 1, 4, 5, 6, 7, 8, and 9, 11. The defendant insert.
Let me just, we don't need to have you read this whole document.
Okay.
I've read it.
Okay.
All right? It's 8 pages long. It's on file with the court.
Okay.
Is there anything else you want to say in addition to what is written in your motion? Do you want to make any other statement?
Yes, the courts know that I filed a federal suit. I forgot the exact date of last February. I filed a federal suit, and you was mentioned as a material witness, and you along with 6 other additional judges, and I have evidence to prove that not the search warrant right here is signed by you. The affidavit in support of the warrant is defective because, according to Wisconsin statutes,
Let me just interject you right here so we make something perfectly clear.
Okay.
I was assigned this case. This case has got a lot of history. Would you agree with me?
yes.
Okay. So I'm new to the case.
Okay.
All right. I am a reserve judge. Actually, I'm a circuit court judge in power and authority.
Okay.
All circuit court judges have what's called concurrent jurisdiction, or the same authority.
Okay.
This is not an appellate court, all right? It's
Yeah.
my understanding that the search warrant was already ruled on to be admissible, or to be, your motion to suppress the search warrant and anything seized from it was denied. Is that right?
I don't. I was never ever afforded the opportunity to present my motions, kind of like what you allowed me to read the motion. I was never, prior Judge Faye Fletcher never allowed me to present my motion. So like even today, like it's been motions, orders, and several different things that were supposed to be presented to the courts, but I have never been afforded the opportunity to present my evidence.
It's my understanding from looking at the record here that Judge Blanchard ruled and denied your motion as it relates to the search warrant. Would you agree with me?
But I never presented it.
I understand that. That might be your position, but she already ruled, right?
She made other, yes, she did rule.
On the search warrant.
But she also ruled that for the state to bring forth the original search warrants, and I still haven't received it.
Well, there's one on file that you sent me a copy of. But at any rate, the search warrant, in my opinion, based on the record and the information available to me, has already been ruled on by another judge. My point is this. If another judge makes a ruling, that ruling stands. I can't review that ruling. I can't change it. We can't go back to that. We go forward in time. You understand what I'm saying? If a judge makes a ruling in a case who's a circuit court judge or, like me, a reserve judge, people with the same authority, we don't have authority to review one another's decisions, all right? So if Judge Blanchard already ruled that the search warrant, your motion regarding the search warrant should be denied, then that's water under the bridge, so to speak. And the way you reach that issue, if you want to go further on it, it would be to file an action in a court of review, such as the Court of Appeals in the state of Wisconsin. You understand?
Kind of, but it's kind of ambiguous because it's also been several other rulings that was ruled in my favor before Fletcher, and she also re-ruled on rulings that was ruled, and in the clerk of court, Racine County Clerk of Court told me personally that the search warrants don't exist, and so it was. Fletcher also ruled that the state is supposed to present me with the original search warrants, and then she went back and changed the ruling, and so I still never even seen the search warrants. I got, like for instance, the warrant with your signature on is 2 different versions of the same warrant, and then the affidavit is defective because it's not even in compliance or anything sworn to is mandated that they have a notary seal, and also the jurat is supposed to be on the same page. If not, it's supposed to be a note stating that.
Okay, you're arguing the search warrant. In my opinion, from what I know of the record, that issue is already decided, all right? Not by this court, but by previous judges who've heard this case, including Judge Blanchard, all right? So the point is, we're not going to re-argue whether the search warrant is valid or not. That's an issue that's been decided, and if you want to reach that issue again, you have to do it on appeal. You understand?
I understand what you're saying.
All right, so you can go forward with your, I'll ask you, Mr. Wiedenfeld, anything on that issue regarding the search warrant and previous history of this case?
I don't have anything regarding the search warrant, but I did wish to make a record regarding discovery, because I know the defendant did mention that there were some documents that he wanted that he hadn't received. At the previous hearing, Judge Fletcher ordered that copies of certain discovery materials be made, and that they be made available to the defendant. I do have copies of those documents. I don't believe he's ever picked them up or received them, so I did bring a stack of discovery documents for the defendant today to provide him in court.
Okay, all right, you can do that. So let's go forward. You have that number. You're not going to have time to review that now. We're going to have to stop here to let you review that. There's volumes of material he just gave you, okay? You can review that later and respond to it accordingly. But that issue is simply him presenting you with documents at this point, all right?
Yes.
Let's go back to your motion that we started with here, which is your motion to have me removed from this case or recuse myself.
Yep.
Okay, so getting beyond the search warrant, anything else you want to say?
Yes, I also object to, what was your name again?
Zeke Wiedenfeld.
Okay, according to Wisconsin statutes 978045, appointment of a special prosecutor, it says, section BM states that the judge may appoint an attorney or a special prosecutor only if the judge or the requesting district attorney submits an affidavit to the Department of Administration attesting that any of the following conditions exist. And so, as of today, there haven't been any, affidavits, sworn affidavits attested to by, this special prosecutor. And also, Racine County also stated that this is not a Racine County case, and gave me a letter in writing that this is not a Racine County case. And I have never ever even been in Walworth until I was ordered by the judge to drive up to Walworth County to get this same discovery right here. And they keep charging me. Like, as soon as I open this up, I noticed that I'm being recharged for documents that I already have. on me. And one of the main things that I requested is, like this CD right here, I already have this. I explained it. I explained to the court several times that I already have these. They, in Walworth County and Racine County, keep charging me over and over and over for the same documents. I was requesting an August 21st interview with investigator Brian Van Sock, and him interviewing Josh Golden on August 21st, 2015, and he wrote in the report that the interview was audio and video recorded.
We're getting off topic here. I'd like to try to keep this on topic.
Okay.
We wandered into the discovery issue now, but let's stay, for now, let's stay with your motion for this court to recuse itself. Is there
Okay.
anything you want to say about whether this court should remove itself or not?
Yes, like as I stated, but you kind of shut down my motion by not letting me present the search warrants that the legal custodian of record said that don't exist.
Well, they're already presented. You filed them as exhibits with your motion, right?
I was given these search warrants while I was incarcerated. First, I was given the warrants with the wrong issue dated, and they wasn't signed by a judge at all. As I displayed as exhibit.
Yes, there's an unsigned version, and then there's one that's signed.
Right.
Okay.
So then later on, after I've made an issue about me wanting to see a search warrant with an affidavit with the judge's endorsement, then all of a sudden my attorneys provided me with signed copies. And then once I was in jail facing revocation, once the administrative law judge found me, they dismissed my allegations that was pertaining to this criminal case. I posted by me and my attorney that I got that I hired when I got out. We could never ever get the search warrant, so we met up on March 4th and April 14th, 2016 at the felony case office and the DA office and the office here on multiple occasions trying to obtain the search warrants, because even though I got search warrants, I still don't have all of them. And some of the search warrants that I received had missing mandatory information on them. When I read police reports, they're referring to search warrants that I never got copies of. It's just so much. So I wanted to exercise my right to inspect the original search warrant.
Again, we're getting off topic. The topic at this point is whether this court should remain on this case or recuse itself. Is there anything you want to say about that beyond what you've stated so far? You're talking about discovery issues, you're talking about effective search warrants, but what do those matters have to do with whether this court should remove itself, okay?
Oh, I mean, basically, you sign a search warrant that's in question, the validity. I filed a civil suit, and I mean, you were a material witness, so I mean, it's only lawful that you need to recuse yourself from the case.
All right, I understand your point. Mr. Waitenfeld, anything you want to say about his motion for this court to recuse itself?
I believe that the court can properly preside over this matter, that you have the authority to preside over the matter. I understand that there is a matter that's been filed in federal court asking to change jurisdiction. I don't believe any decisions come down on that federal case, so I believe this circuit court would still have the authority to preside over the matter.
All right. Then it issues whether this court should recuse itself. As argued by Mr. Barker, I believe that because this court signed a search warrant, which he questions the validity of, which has been ruled upon to be valid by another court, that this court should remove itself. What a search warrant is a document allowing a law enforcement officer, to go to a certain place to recover evidence of a crime. This search warrant, the one that Mr. Barker attached as an exhibit that's already in the file in other places, was one which was signed by this court on April 29th at 7:15 or 7:10 in the evening when an officer came, I believe perhaps to my home, although I'm not sure of that. Could have been somewhere else, but it was an evening time when the search warrant was signed by the court. The officer, once receiving it, writes the date he got it and the time he received it on the back it's on page 2 at the top, and then signs it himself when he receives it. He then executes it and then returns it. When a search warrant is executed, they go to the place, show the people the papers, take the items that they're able to recover in the process of the search warrant, and once it's been served or executed, they then return the search warrant, which is the third set of signatures there that relates to when they return it to the clerk of courts, and that is indicated to be on April 30th at 11:30 a.m. And then when the clerk of courts receives it, it's stamped by them, and there's a stamp on it for April 30th in the clerk of court's office, received and received. The way the search warrants are handled is when a search warrant is returned to the clerk of courts, they simply go into a file, which is a search warrant file, and they remain there until they're used for some other purpose, such as they're needed in a case, because not every case where a search warrant is used has issues that relate to the search warrant. So the search warrant remains in the clerk's office in a file until such time as someone, whether it be a defendant, a clerk, a judge, an attorney on the case, asks that the search warrant be produced to be made a part of the criminal file, which is pending. So search warrants are common in criminal cases. There's no law that I'm aware of that says that because the judge may have signed a search warrant that would have yielded perhaps evidence that could be used in a case that the judge could recuse himself, or should recuse himself or herself. There's nothing to suggest in this case that my personal observation and my personal knowledge of what I know of this case, other than having just gotten in contact with it in the last few days, I know nothing about it other than what I've read. I don't know any facts about the case other than what's in the file. I have no reason, I have no contact previously, as far as I know, with Mr. James Barker III, although I've been around for a long time. Retired after 28 years as a judge, and 8 years before that as DA, and 5 years before that as an assistant DA. So, you know, our paths may have crossed, but I have actually no personal recollection of you. So many people come before a court that I don't have any memory of you or have any sense that I should in any way feel that I'd be unfair to you. So, motion at this point is addressed to the court's discretion. I don't feel there's any reason why I should recuse myself. I feel that I can be fair and impartial, and I'll deny your motion to have myself removed from the case, all right? So then we'll go on to your next motion, which is a motion to dismiss, all right? And again, I've read that, and I have the state's response. And Mr. Barker, you want to address that?
Well, like so much has happened in between my last court date and now, I didn't know what this court appearance, what was going to happen. So I was expected to get contacted by the DA office with this before this court date. So I actually didn't even come prepared to argue this motion. I was given two different court. I was told to be at branch 1 in the other building. The DA had changed like 4 times. My court date had changed. There was never any specific information on what this court date was for. So just on the 6th, which was Friday, I just found out that you was the judge. So I had no idea what this court date was for.
Well,
So
this is not a new date. It was set by Judge Blanchard some time ago, right?
yeah, but in the meantime, Judge Blanchard told me that she wasn't going to recuse herself, and then all of a sudden she recused herself, and then she said that then all of a sudden I had a Madison special prosecutor, and then it went back to Haley Johnson, and then it changed to the DA sitting here now, and they never told me why my original court date that was scheduled, I believe, for March 26th was changed. I just got a notice saying that my court date was changed to April 9th, but it was I never knew exactly what I was coming to court for today, other than Friday I got a notice from saying that you was going to be my new judge. So I've been very confused on what's going on.
Did you write this motion to dismiss with prejudice?
Yes,
And it's, let's see how long is it? It's 17 pages long.
probably so, but I also said that I was going to amend the motion, and Judge Fletcher ordered for them to provide me with the discovery, and I couldn't amend the motion until I received the discovery, and I'm just now getting the discovery today here in court. And when I look in the discovery, all the things that's inside the Judge Fletcher's order, the stuff that ain't even inside the folder. There was a specific recording that I requested, and it's an August 21st interview, 2015, with investigator Brian Van Sock and Judge Golden. And
So you're asking for an adjournment at this point of your motion hearing?
Yes, I am.
What's the state's position on that?
I know that this case has been going on for a very lengthy period of time, but I also recognize that I did just provide Mr. Barker with some additional materials that he might want to review. I agree that Judge Fletcher's previous order gave him some time to amend his motion if he wanted. I don't object out of fairness to giving him additional time to amend his motion or make changes to the court.
All right.
And can we further address the motion to object to? Is this court required to follow common law and Supreme Court rulings? Because we never addressed the 978045 where he's supposed to swear to an affidavit and submit it to the Department of Administration.
Did you file a motion in that regard?
Did I file a motion in that regard?
To have the DA removed?
Well, like I said, it seemed like everything is just strategic. Like I'm finding out just my last court.
Okay, well, the court operates on what's called notice.
Right.
If you want to bring a motion, you file a piece of paper that tells people what you want to have heard. Have you filed a written motion and given the DA and the court notice of your intent, your request to remove the DA?
Yes, but not with him, with Haley Joe Johnson, yes, for the same purposes. There's no notice, so he's operating outside of jurisdiction to even be in here representing the.
All right, well, in terms of that issue, Mr. Wiesfeld?
Sure. There was originally an order appointing Haley Johnson, who is an assistant DA in the Waller County DA's office, to appear on this matter. She's out on maternity leave right now. I did ask and have a new order appointing me as the district attorney in Waller County or my designee to appear on this matter. So there is an order that's been signed by Judge Boyle, appointing me as the special prosecutor in this matter, or my designee. So I anticipate it'll be myself or Attorney Johnson appearing at future hearings.
All right.
I'm looking at that form he's talking about, and it's not even attested. That's mandatory Wisconsin statute 137.01 section 4. I don't even see a notary seal on there. He looking at a bank. Why did that file? That's not even filed. I should have a copy of that.
I'm not sure if it was electronically filed or not, but I will electronically file a copy after today's hearing. And I don't know if the defendant has opted into e-filing, but I'll send him a copy.
Have you opted to participate as an e-filing?
Yes, I am an e-filer.
Okay.
Yes, I am, and I object to that. I mean, now he's going to go back and all of a sudden file a document. Look at the document. Can you present the document to the court? Because it's not even, I don't even see nothing on it.
Okay. What we're going to do is, we're continuing the matter to hear your motion to dismiss, which I'll allow you to do. We'll continue on the issue of the authority of the special prosecutor to be appointed in this case and to remain on this case, all right? So he'll remain at this point until we hear that issue as well, all right?
Can you force him to present with that document? 'Cause I'm looking
He's
at the
already
document.
said he's going to file a document, so he'll file it and he'll give you a copy, okay?
What I'm saying is the document, I'm looking at the document, it's not, where is it
not-
written on? Where is it?
Okay.
It's not attested.
He hasn't given you anything. You're looking over his shoulder on papers on his desk. So see what he files and then deal with it once he files something, okay? you're just guessing at what's on the piece of paper he has or whether it's complete or not. So
With all
we'll
due-
deal with facts, things have to be filed with the court. You can file your motion to have this prosecutor removed if you wish, and we'll hear it, all right? So let's give you another date here for a motion hearing, which I'm reluctant to do. This case is as old as a case might be in this whole system. I'm gonna guess it's probably the oldest pending case, in part because, you know, you're difficult in terms of wanting to go forward and move efficiently forward. You've had 9 lawyers, as I counted in this case,
Yes.
which means, you know, you haven't been able to establish and maintain a good working relationship with someone who would be helpful to you in your defense, and that's your choice. At this point, you're choosing to go forward on your own, and I know that the Public Defender's Office has indicated they will not appoint another attorney to represent you because of the history here. So, you know, don't be your own worst enemy is my point. You need to think about the things that you do and how they affect you as this case moves forward, and we will move it forward as quickly as we can to conclusion. I was prepared today to give you a trial date, but we're going to set another motion date in a couple weeks. Just a couple weeks.
We can do April 26th at 1:30.
Can I finish addressing the discovery issue, because I've been going through this same issue for the
You
last
haven't
couple
even had
years.
it, you just presented it today. Go take those documents and look through them and see what's there, okay?
Yeah, but this is the issue right here, one of the main
Okay,
issues.
well, we'll deal with that when you look through it all, and if there's another issue with respect to some interview document, we'll talk about that. We're not talking about it now. Discovery's not on the agenda today. The 2 things on the agenda were the motions that you filed, so look at that, and if you think there's still some things missing, then file a motion, another motion regarding the lack of discovery, okay? And what you're looking for, be specific, all right?
It's on the order, with all due respect. It's on the order, all the discovery. I have specified it since December 1st on record in court, for the discovery that I am seeking. And every time I come to court, I get handed the same documents over and over again.
Okay, I hear that. You said that before, okay? To your knowledge, Mr. Wiedenfeld, are there any other videotaped or CDs that might exist of interviews?
No, I have a list from the court's previous ruling. The items that I gave the defendant are recordings of all, but there's 2 recorded interviews that he's asking for that don't exist. The one being the August 21st, 2015 recording of the interview with Joshua Golden. Law enforcement looked into it and that recording doesn't exist. The other recording that was discussed was April 23rd, 2015 recording of the interview with Evan McNeil.
All right. So you have a statement that they don't exist, and you can't produce them if they don't exist.
Well,
right?
now, can I state for the record?
I know you've got a report that you want to read from an investigation, right?
Yes, the officer that's sitting right there, I'm only asking for these specific discovery material because Officer Van Scott sitting right there wrote that these things exist in his report. So if he's saying that this stuff don't exist, that means that he has fabricated discovery. And that's called spoliation or whatever it says, spoliation, the state lost or destroyed exculpatory evidence. This interview that I'm requesting is exculpatory evidence. He tried to establish a connection between, a conspiracy between me and the defendant, and all of a sudden...
You are the defendant.
The co-defendant, one of the co-defendants. And he stated verbatim inside of the April 21st, 2015 report that this interview was audio and video recorded. That's what he stated in the last paragraph of the report. And also...
Right. Okay, let's stop there, okay? Mr. Wiedenfeld, without responding, I'm going to have you prepare like a written memo to the court, to the defendant, regarding those points. What are the videos that he's requesting? Do they exist or not? And if the officer made reference to them in his report, make an explanation as to why that statement was made and what may have happened to them or whether they were done or not, okay? So we
Yes.
know what the facts are there. And we'll have him file that and we can talk about that next time, all right? You get a copy of his explanation to you and to the court about what the things are that you're concerned about with respect to discovery, okay? So we'll have that come up next time, and then we'll deal with your motion to dismiss, and then you can talk about discovery further, and we'll go forward. So that date again will be,
April 26th at 1:30.
they don't have a courtroom that's assigned to me. I have to sit wherever there's an available courtroom, so pay attention to what's online and also what notices are posted on the doors of the courthouse to see where we'll be if they change, depending on availability. And then we're going to give you a trial date at this point as well. And let's see. We have May 29th at 1:30 for trial. That's a Tuesday afternoon, and then we proceed at that time with jury selection and go forward, all right? Any objection to that date?
No, I don't have any objection, but yes, I do have an objection because until I know until I have a right to discovery. Am I correct?
You are correct, and we'll deal with that next time once he gives you the memo about the things you're looking to. I can't order him to produce them if they don't exist. We need an explanation from the state about what if what you say is correct about the police report, then they need to make an explanation about what that statement was made for and what happened afterwards as to whether or not there was a videotape or wasn't a videotape and what happened to it. And then you can deal with it from that point on. I can't make them produce something that they don't have, okay? If they don't have it, all right?
So you're telling me that the officer can write false information in a report and it's just, you can't make them, you can...
I don't know what the circumstances are about why he wrote that. If he did write that, we'll deal with that at the time we get together next time on the issue of discovery, okay? So anything else today, Mr. Golden? I'm sorry, Mr. Barker?
Let's see here, let me check my notes.
You only filed two motions. We're not going to discuss the motion to dismiss because the DA has agreed and I've allowed an adjournment so you can be prepared. Although I think you probably are about as prepared as you can be since you're the author of this motion that you filed.
What about, it was an order on June 2015 for the return of my father's. It was an order by the judge for the
Is that
return.
your property?
It's part of my, yes, it was seized from my home and it was ordered for the return. And it also shows the execution of the unsigned search warrant on my house, which is a violation of my Fourth Amendment.
Okay, you keep mixing issues here. What is the property referring to?
It's the video recording of the actual raid on my property.
No, you said the things that were seized, you want them returned. You're getting things all mixed up here.
Yeah, no.
What is it that you want returned?
It's the LA View surveillance system, digital surveillance system.
From?
1412 West 6th Street. It was ordered in June of 2015 to be returned, and it still haven't been returned.
Mr. Wiedenfeld, on return of some property of someone else?
The surveillance system wasn't ordered to be returned. The defendant was directed to work with the sheriff's department to arrange to view those items, and I believe that the court did permit him to view those items. I don't know if he's made those arrangements or not. It sounds like he has not made an arrangement to view them, but they were not ordered returned.
At the prior court date, Blanchard told the state to put them on a disc or something and provide them to me, and I still haven't received them. It's only one disc, and it's a disc that I already have inside of this folder. So it's supposed to be multiple discs.
I thought you wanted the security system returned physically. You want?
Yeah, I mean, it was ordered returned, but then she changed it from, okay, well, we're not going to give you. They said that they backed up the video onto a flash drive. So I was supposed to pay $5 for the flash drive, but the significance of the evidence isn't the box itself, it's the video on it. So the state has admitted that they took the video off of it, but they're not allowing me to use the video or returning it back to my father. So I want to use the video to see what happened on April 20, which I do have on what happened on April 23rd, 2015, and to use it as evidence. And I also have a video of them executing the unsigned search warrant and showing it on camera, which is a violation of my Fourth Amendment right. But it seems to me that I don't have any constitutional rights in this Racine County courtroom.
What is the status of the security system? Is it still physically being held, and what is the status of the information that may have been reported on the system?
The assumption is that it has been downloaded off of the security system, but I don't have that verified. I just know that the order from the previous hearing was that he could go and view that surveillance system at the sheriff's office.
So is the state objecting to returning the surveillance system? It's being held as evidence, or I'm confused here. Apparently, Judge Blanchard indicated that the system itself, the physical equipment, could be returned once you had obtained this copy of what's on it from the standpoint of being relevant evidence to this case, or is the state asking that the court continue to order the security systems of physical equipment to be held? I guess is my question.
I'm asking that it continue to be held as evidence, since I don't know at this time whether all the data and information has been recovered from it. But even if there is data and information recovered from it, I don't want to raise additional concerns about evidence being manipulated or falsified.
Okay. Is there objection to its return?
Well, I would like to object to what he said. It's digital evidence. It's a box, a digital
I
evidence.
understand.
I got alleged crime lab receipts. The purpose of the seizure of the box was for them to take the box, back up the video onto a flash drive for them to keep, and to return the box. So everything that they have, I will have. So they have their copy already. So what's the problem with returning the video unless they're trying to conceal something? That could be the only purpose of them not wanting to return the box, because they got what they want off the box already. They even documented inside of Discovery that we have the video, we have extracted the video from it. So now they don't want to give back the box, and that's because if the box holds exculpatory evidence that will liberate me from this criminal case, and they're concealing it from me, which is a violation of my due process rights.
In terms of giving the defendant a copy of what is on the surveillance system, Mr. Wiesenfeld, has that been done?
I don't believe so. I'll look into whether there has been contents downloaded off of that twice, and if they have, I'll certainly make sure that a copy is provided to the defendant.
All right. Okay, he's gonna look and see what's on there, and if there's more information, he'll get it downloaded and give you a copy of what's on it. For now, I'm not gonna order a return of the equipment. It's possibly, again, recorded evidence. I don't know in terms of the scope of this case and people involved in the movement of what I'll refer to as product, which is the issue here about merchandise or manufactured product of employer. That's that issue, and whether that may show movement of those sorts of things in and out, I don't know. I guess that's always a possibility, but I think that they're entitled to hold the equipment as evidence at this point, but they are willing to, and I think they're required to give you copies of what the data is that's on that system. All right?
They're also stating that a video, I did on April 23rd on my initial arrest, I did 2 interviews with the Racine County Sheriffs. They're telling me that an interview that I know I sat and had with an investigator don't exist, when I know I sat there and had the interview.
And what was the date you believe that occurred on?
April 23rd, 2015.
All right, I'll ask you to address that as well in the memo, Mr. Wiesenfeld, about what evidence there is of video interviews of the defendant and other witnesses, and if it doesn't exist, then state so in your memo, please, okay?
Sure. I can advise the court that the disc that is in this additional discovery materials is the recorded interview. I don't, if now he's saying that there's 2, I don't know if there's a second. I'll look into whether there's additional interviews, but I believe that he has his recorded interview.
All right.
Well, you can look at Investigative Vandervest 4/23/2015 report, and also Investigative Brian Van Zyl 4/24 report. And in both of those reports, they stated that Investigative Vandervest, in the last paragraph of page 1, he stated that he interviewed me at 7:45 a.m. That interview was missing.
Okay.
And also, on page 4 of his 4/24 report, he states that he interviewed Yvonne McNeil, and the video says verbatim, the interview was audio recorded. Yvonne McNeil submitted a 6-page sworn affidavit objecting, stating that and she also submitted all the corroborating evidence to prove that his entire 6-page report is fabricated, and I would like to present that or have her testify on the disposition hearing, and also.
We'll deal with that in terms of who the witnesses are you want to have subpoenaed for the trial, okay? You should prepare a list of witnesses who you want to have subpoenaed and their addresses and so on, so that subpoenas can be prepared and sent to them, okay?
Don't I have a right before trial to present evidence?
Again, we have a motion here, you can present evidence in support of the motion if you want to.
Right.
But it depends on, what the basis is. And when we have a motion hearing, we look at what you argued, and you have the right to present evidence if it's relevant to the motions you're bringing, okay? So you can do that next time we have a hearing on your motion to dismiss, if your motion to dismiss relates to that issue and that evidence you just referred to. But I don't know whether it does or doesn't.
Question. Do I have a Fourth Amendment right?
Okay, I'm not going to answer that question in terms of what are you referring to?
I have video of the officers executing an unsigned search warrant on my property, flashing the unsigned search warrant on camera. No signature, no endorsement from a judge.
Again,
I've been trying to, the clerk of court, I have video of the Racine County Clerk of Court telling me that that search warrant don't exist. This is my Fourth Amendment rights at stake. I'm just only trying to exercise my right. I would like for the court to abide by the rule of law, common law, and the Supreme Court rulings. I have the law backing me, but it seems to me that it's
we'll
not.
deal with these issues one at a time, as you've already addressed them. I've already told you the search warrant's been ruled upon. We're not going backward here, okay? That's ruling stands, and you can appeal to the Court of Appeals on that issue. With respect to your motion to dismiss, we'll hear that next time, and we'll deal with these discovery issues that you brought, and we'll wrap that up next time and be prepared for a jury trial on May 29th at 1:30. All right?
Furthermore, the search warrants. You keep saying that the search warrants have been ruled. They haven't been ruled. I've been saying since December 1st on record that I haven't received all the search warrants. I have a right to inspect. Every search warrant and affidavit is supposed to have a clear impression of a notary seal. I have not.
Again, you're re-arguing the issue of this search warrant that's on file here. We're not going backward, that's been dealt with, all right? Anything else besides that you want to say today? We will hear your motion to dismiss next time, all right? For today, I've denied your motion to have this court recuse itself, and we'll proceed on the date of April 26th at 1:30 at the location to be determined by the clerk of court's office, all right?
Yeah.
Judge, regarding the trial date, the investigator advised me he's not available the
Right.
date that was selected.
How about June 5th? All right.
Well, June 5th is actually my birthday, so I would rather not be dealing with court on my birthday.
You want to start on the 6th, we can do that. With the one less day of the week that's available for the trial.
So you're saying like my next court date is going to be trial?
No, your next court date is the date I gave you. I hope you wrote it down. April 26th at 1:30 for the motion hearing, and June 6th now for the jury trial, all right? Anything else, Mr. Wiedenfeld? No. Okay. All right, then we're through today. We'll see you on those dates. Again, that's April 26th at 1:30 for a motion hearing to continue these motions and to conclude them. And then a jury trial will be on June 6th at 1:30. All right? Thank you.
So I was talking to,
Oh, you were?